Your Excellencies, distinguished guests, ladies and gentlemen, very good evening to all. With great joy and immense pleasure, I feel privileged to extend my warm welcome to all presented here for the valedictory session of Third International Conference on Mediation. I feel proud and honored to be here in front of this virtual gathering. We have our chief guest, Honorable Mr. Justice P.S. Narasimha, Judge, Supreme Court of India, and former member of Mediation and Conciliation Project Committee, Supreme Court of India. President, Honorable Mr. Justice Deepak Mishra, former Chief Justice, Supreme Court of India. Guest of honor, Honorable Mr. Justice Amreshwar Pratap Sahi, Director, National Judicial Academy, India, and former Chief Justice, Patna and Madras High Court. Guest of honor, Honorable Mr. Justice G.S. Sandhawalia, Judge, Punjab and Haryana High Court. Patron, Professor Dr. Usha Tandon, Dean and Head, Faculty of Law, University of Delhi. Professor Dr. Maharaj K. Pandit, CEO, Institution of Eminence, University of Delhi. A warm welcome to you all. Winston Churchill said, and I quote, "We make a living by what we get, but we make a life by what we give." To make a mediation successful, one should be like a selfless candles. We should try to serve and give to create joy and happiness in the life of others. Thereby, we can remove the darkness of conflicts in the minds of the people. Now, I request Professor Dr. Maharaj K. Pandit, CEO, Institution of Eminence, University of Delhi, to deliver the welcome address. Over to you, sir.
Yeah, there was some change.
Will give the welcome address.
So I'll take it. Yeah. So let me have this privilege of welcoming our esteemed guests. Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court of India and the chief guest of this occasion. Honorable Mr. Justice Deepak Mishra, former Chief Justice of India and the President of this valedictory session. Honorable Mr. Justice Amreshwar Pratap Sahi, Director, National Judicial Academy, India and former Chief Justice of Patna and Madras High Court. Honorable Mr. Justice G.S. Sandhawalia, Judge, Punjab and Haryana High Court. And Ms. Sonal Patil. Well, I'm extremely delighted to welcome our distinguished panelist of this valedictory session, which is wherein we are concluding the two-day international conference on the mediation. It is indeed an honor and privilege for us, Lordships, Lordship Narasimha, Lordship Mr. Justice Mishra, Honorable Justice Sahi, Honorable Justice Sandhawalia, to have you on this platform for this particular cause of the valedictory session, sir. I'm also delighted to welcome the participants, the judicial officers who have been connected with this particular program. May I bring to the knowledge of our lordships said that there are two links. One of the link is with which we, the speakers, are connected, which may be showing a very small number. But then there is another link, which is a public on YouTube link, to which from which the participants are connected therein. And it's quite heartening to share with you that as many as more than 5,000 judicial officers have registered for this particular program. And apart from that, we are also having the registrations from persons who are not from the judicial category, but who are keen to hone their skills in the mediation. I extend a warm welcome to all Ms. Ramnathan and the other panelists, everyone who is connected at this particular moment with this program. Last but not the least, I take immense pleasure to welcome the conference director, none else than this Dr. Ashutosh Mishra, who has really worked day and night to make this conference successful. As a matter of fact, he's the heart and soul of this particular conference, and it is his dedication and I will say the sincerity and the teamwork that you see how meticulously at the 5 p.m. when it is the last session, military session, we may be just 2 minutes late. It's a very challenging task for any conference organizers to maintain that time there in the sessions. And I'm so happy that as a director, Dr. Ashutosh is maintaining this thing also. So before the Lordships, I really acknowledge his dedication, hardship. Why? Because I'm really looking forward for more such conferences coming from my colleagues like him here in the Faculty of Law, University of Delhi. Well, these 2 days have been very enriching for all of us. Various aspects of mediation, which was spread into 9 technical sessions, have been discussed threadbare. And the feedback which I got is that the speakers have been excellent. Why? Because all our speakers have been those who had been working in that particular area for long. Just now, I was in a session which was on the mediation bill. And from the creator to the critique, uh, if I divide the speakers, I can really divide them from these 2 categories, and it was very interesting. The only thing is that we were just short of time, and therefore we were just wondering, can we have another conference also, which is devoted to this bill? Well, this is not a time that I should speak longer. Why? Because we are looking forward and keen to listen our distinguished speakers, and therefore I wind up my address by welcoming our chief guest, president, guest of honor, and all. Once again, thank you.
Thank you so much, ma'am, for your kind-heartedness and a warm welcome. We have a guest of honor, Honorable Mr. Justice G.S. Sandhawalia. His Lordship is a member of Mediation and Conciliation Committee of the Punjab and Haryana High Court and has commendable work in encouraging effective participation of lawyers in the process of guiding mediators to adopt a more humanitarian approach to the dispute resolution. So, I would like to request our guest of honor, Honorable Mr. Justice G.S. Sandhawalia, to kindly address the august gathering. Over to you, sir.
Good evening, everybody. As we wrap up the second day of this brainstorming session, it is organized by the Faculty of Law, the Department of Public Policy and Governance. If I correctly remember, Professor Misra would remember that maybe 3 years back in 2019, we were there earlier at the same time. So it is after our breakup 3 years that we are here again. And the kind of progress which we've seen in the 3 years, in spite of the setback that we've had over the last 2 years of being locked up, is very heartening to know. My role or speaker today is basically to sum up what has happened over the last 2 days. So I can just, as possible in this short 10 minutes which I have, I can just brief up everyone who was maybe not able to participate for reasons because of their commitments elsewhere. As we know that the chief guest, Justice Sanjay Kishan Kaul, Judge Supreme Court, and the member Mediation Conciliation Project Committee, he enlightened us with their valuable insight on mediations and the importance in today's world when peace and harmony is the utmost need of the society. Justice Kaul covered all significant aspects of mediation and its importance as an alternative dispute, a resolution mechanism to achieve the goal of speedy and equitable justice. By the Vice Chancellor of the University of Delhi, Professor Dr. Yogesh Singh, addressed mediation as an age-old tradition, and he quoted beautifully from the Mahabharata, that is the oldest attempt between the Kauravas and Pandavas when mediation first was recognized. Justice Ravi Malivat, Chief Justice of the Madhya Pradesh High Court, has given us a detailed insight of the provision of the proposed mediation bill. And similarly, Justice Divakar of the Allahabad High Court covered all the aspects of mediation and a special emphasis on community mediation and importance in establishing the harmonious society. The first session was, as we know, on community mediation and mediation as an indigenous form of dispute settlement in the Indian perspective. It started with a welcome speech by Professor Dr. Rajni Abi, Faculty of Law. Madam Geeta Rameshan shared her views on the community mediation and emphasized on training of professionals, mediators for better understanding the inequalities and the inequities coupled with her rich experience. Madam Giripala Singh, Secretary, shared her experience of successfully resolving the dispute among the tribal communities of Madhya Pradesh, where accessibility to justice is still a challenge. She also talked about the Gram Nyalayas and the litigation clinics. Justice Bhartiya Chakravarti of the Madras High Court talked about Mahatma Gandhi ji's philosophy of resolving disputes and emphasized the role and importance of servicemen, even like a barber and the postman, the faith mediator, the priest and the pastor. The government agencies like policing resolving the disputes at various grassroots levels. The minister today also referred to the issues which arise at the village level, where basic small disputes regarding 323, 324 do come up, and how they need to be resolved the earliest, rather than parties wasting their time continuing with litigation at the end of the day, earning acquittals on account of the trials which are at basically magisterial level. Justice Kulkarni of the Bombay High Court also addressed the mediators as the peacemakers of the society, and he emphasized on the history of mediation and asserted on the need of the neighborhood justice centers. The second session was on online mediation challenges and opportunities. Dr. Ranjit Mehta, the industry advisor, and Justice Puneet Gupta talked about the various challenges faced in conducting online mediation and the lack of digital infrastructure and how to overcome all these challenges. It's a player, of course, as we know, with all this infrastructure coming in, that we are all sitting at our respective places and able to interact. Somebody in Madras, somebody in Guwahati, Delhi, Gujarat. And of course, the fact that there's a mediation conference going on at Gujarat in a big way. And which goes on to show that, yes, mediation is here to stay. Shri Anil Xavier, the president of the Indian Institute of Arbitration and Mediation, and Justice Sanjay Dwivedi, judge of the Madhya Pradesh High Court, also discussed about the importance of the standardized procedure of ODR and various online tools to solve the conventional problems. Justice Koteshwar Singh of the Guwahati High Court brought light the Lok Adalats and the other commendable ODR forms which have gathered pace over the years to guarantee speedy justice to people. The opportunity has now been grabbed by giving it an enforceable mandate, as we are all discussing. The third session was on pre-litigation mediation, the context of ease of doing business. Mr. A. J. Jawad, the mediator and partner head of ADR, KD Lex Chambers, talked about the origin and the emphasis on the game-changing role of new mediation. And Dr. Subhash Chandra Pandey, former Special Secretary, Ministry of Commerce, Government of India, emphasized on the important individual role in strengthening mediation with the help of judicial components and laws. Shri G.R. Raghavendran, Joint Secretary of India, briefed us about the Commerce Codes Act 2015 and briefed us on the pre-mediation laws. Justice S.R. Krishna Kumar, Judge of the Karnataka High Court, and Justice Govindaraj, Judge Madras High Court, also emphasized on all the workable aspects of pre-litigation mediation, which is mandatory for proper functioning. It is important, as we notice, that foreign investors have to be attracted. And this is one of a method, at least, that ease of doing business is important, and how to resolve disputes. Commercial disputes herein are known to drag on for the best. Of course, the bar also enjoys the dragging on because of their personal interests also, but it has become a bane also for foreign investors. The fourth session, which we talked about, was the role of mediation in family and matrimonial disputes. This is one topic which I would say occupies a large quantum of work which comes out of matrimonial disputes in mediation, at least in this part of the country. Of course, in bigger towns, the commercial aspect is also gaining a lot of importance. All the eminent speakers talked about the family and matrimonial disputes and its consequences on entire families. When on one hand, speakers like Iriam Majid and Dr. Paramala Acharya and Justice Anjali Palo enlightened us with the role of emotional stability and intelligence in tackling such critical situations. Madam Uma Ramanathan and Justice Sandeep Mehta and Chief Justice Sanjay Karol of the Patna High Court talked about important in deciding the role of the mediator in the destiny of the family. They also focused on special training programs for mediators to deal with such situations with unbiasedness and sensitivity. On the second day, the role of the mediation came up in commercial and IPR disputes. The Shri Tejas Karya, partner of Shardul Amarchand Mangaldas, talked about the mediation has not been used much for solving commercial disputes on account, and stressed that time is equivalent to money in commercial disputes and mediation should provide better confidentiality. Professor V.K. Ahuja, the Vice Chancellor, said that mediation rules don't apply where applications of interim injunction has to be filed, and mediation rules 18 lay down the ethics to be followed by the mediators. And he discussed about the need for confidentiality. On the fifth session, on the role of mediation in commercial and IPR disputes, again the need was emphasized by Shri Tejas Karya that that the institutional mediation should be included, which is now the new amendment which we are talking about. Professor Ahuja also talked about the usage of mediation in various types of disputes, about citing specific disputes which still remain left out. Professor Anant P. Pandit emphasized on the skills and to required to become a good mediator for dispute resolutions and referred to Ramayan for mentioning instances where mediation has happened. Justice Pratap Singh of the Delhi High Court talked about mediation and the role in resolving commercial disputes on time and the fact that it has gained recognition. The sixth session, the role of mediation in environment and infrastructure, which is a new concept also, was talked about by Dr. Rajesh Beniwal, the Director General, who was the special guest and spoke about the legal framework of environmental assessment, impact assessments, and issues related with construction and infrastructure, building, vis-a-vis water, carbon, footprints, green energies, and emission of gases. The second special guest was Shri Abhay Kumar Singh, Chairman and Managing Director for Sonal, who expressed his views over environmental and geological, economical issues and disputes for the lower hydroelectric project. Shri Amit Ghosh was the Additional Secretary from the Ministry of Road and Transport, and he talked about the Arbitration and Conciliation Act and acquiring land for construction. We are all very well aware of a huge number of litigations which NHAI generate over the country, and the hardship which can be caused to people whose land is acquired under the principle of eminent domain, and the delay which it takes in resolving the issues of compensation. And if these can be resolved and with government institutions, it would be a step in the right direction. Justice Anita Sumant, Judge of the Madras High Court, shared her views on different points presented by various speakers in the session. And the last speaker was Justice Ashwani Kumar Mishra, who talked about different aspects and disputes of mediations in different fields. Session 7 was about role of mediation in insurance, banking, and financial services. And there were various suggestions on the digital dispute resolution mechanism and its importance. Shri Vikramjit Banerjee highlighted various relevant aspects that need to be taken to make mediation process successful, and also they quoted the mediation as a solution-oriented. Justice Venkateshwar Alu from the Andhra Pradesh High Court stressed on the accessibility of standard mediation mechanism in semi-urban and rural areas also. And Justice Vivek Thakur from Himachal Pradesh also enlightened us on the journey of mediation from ancient times. The cross-border disputes session 8 and the international mediation also gave us the look at the international perspective. Artificial intelligence was talked about by Mr. Javed, and the information technology role, which was playing a significant role. And he also talked about how online disputes mechanisms were being adopted by the EU in resolving commercial disputes. Dr. Aniruddha Rajput gave emphasis on the credibility of the mediators and the mediation investment with confidentialities. And Justice Ajay Banod talked about the international mediation process as he talked about municipal mediations and implementations of international laws and domestic laws. The latest issue about cross-border disputes redressal is Now we can notice is the battle which goes on in between Ukraine and Russia, and the laudable steps which are being taken and an effort being made to resolve it. Lastly, the session on the 9th session was the Mediation Bill and its perspective. Dr. Leila Olapathy, she talked about the beneficial provisions of the bill and how institutional mediation will help in growth of mediation. And she stated how government disputes can be mediated and showed the provisions of concern and the impact. Dr. Rajiv Mani, the additional secretary, talked about how the system of adversarial system will not be able to provide the required remedy and the heavy burden. I have already referred to Professor Satyapal Singh Bagal, he also referred about how little matters can be resolved. Madam Uma Ramanathan also said that there should be provision for accreditation and licensing for mediators, and talks about the need of monitoring and regulating systems and the need for the people to be aware of their rights. At the end of the day, as we wrap up, we saw that mediation has now progressed over the last 3 years and spread wings in all the fields. And it's getting the legislative acknowledgement in the form of statute. Thus, the stumbling block which we are facing regarding the institutions will also be covered, which is the most important, because the majority of the litigation, at least in large number of courts, are with governments. If we can look at those wings and matters can be solved and secretaries can be given some right of resolving the dispute, it would go a long way in resolving a lot of works which the courts are now. With that, I give my thanks to the organizers for putting us all together and be able to share our thoughts. Thank you.
Thank you so much, Honorable Lordship, for summarizing the gist of the conference. Thank you. Our today's guest of honor, Honorable Mr. Justice Amreshwar Pratap Sahi, is a great example of creating opportunities and guiding every sector of legal field as Director of National Judicial Academy, India. Honorable Lordship having remarkable guidance on Panchayati Raj institutions to act as a mediator in as many disputes as possible at Gram Kachari level. Honorable Lordship is former Chief Justice of Madras High Court and Patna High Court and Judge of Allahabad High Court. Now it will be great privilege for me to request Honorable Lordship to address all of us with his knowledgeable words. Over to you, Honorable Sir.
Good evening. My respects to Honorable Justice Deepak Mishra, former Chief Justice of India, Justice P.S. Narasimha, Judge Supreme Court of India, Justice Sandhawalia, my friend, and I have been in his company for some time. And I had also occupied the chair that was occupied by his late father, the great Justice S.S. Sandhawalia, who was also the Chief Justice of the Patna High Court. I have inherited many legacies. Thank you very much, Dr. Mishra, for this opportunity. Thank you very much for the introduction, Dr. Usha and Sonal. The philosophy behind mediation is to draw parties to a peace and to lead them and lift them out of disputes. With this idea, well, we had the system in our country long back, but now with the modern system of litigation and the various fields in which litigation is growing day by day, well, mediation, according to me, is one of the proper adjuncts to litigation. It is the appropriate dispute mechanism and not the alternative dispute mechanism. Rather, the resounding vote of confidence that I find from the lectures, from the books written on mediation, there is no doubt that mediation tends to bring about peace and harmony. So it is peace which is the pursuit, philosophical pursuit of mediation. Well, what is peace? It was very succinctly said by Shakespeare in Henry IV. A peace is of the nature of a conquest. For then, both parties nobly are subdued, and neither party loses. Now, this is what mediation goes on with, because it is peace with satisfaction, it is peace with honor, and it is peace towards liberty. It liberates mankind of all its pains. And if we remember Thomas Hobbes, he said that the first and fundamental law of nature is peace, and it is to seek and follow it that mankind should carry on his pursuit. Well, we all know that whenever we are bereaved, we say that the soul will rest in peace in heaven. The peace in heaven is ready-made. Everybody is universally a recipient of that peace on his departure from this mortal world. But peace on earth, when it comes to drawing lines of legal battles, well, of course, the good old saying, a lean compromise is better than a fat lawsuit. Well, the mediations that are being carried out through mediators, I would describe these mediators as professional pacifists, because they are pursuing this path of peace. And the origins and the historical evolution of the dispute resolution mechanism in our country can be traced back to the village panchayats. Well, in the Hindi belt, we have read the famous story of Panch Parmeshwar, scribed by none else than late Munshi Premchand. And it is one of those stories which is the foundation of such resolution of disputes. But fortunately, we have risen to the occasion. The West has also risen to the occasion. And now the contemporary model is getting recognition through legislations. The reason being, people don't want litigation. Mediation can be described. I will remember the pioneer of mediation, Mr. Sri Ram Panchu, a senior advocate of the Madras High Court, and I believe many of us are acquainted with him. He said that mediation is called the sleeping giant of ADR. Well, indeed, the process of consensual resolution, where everybody participates in it with full satisfaction. Well, this was the same pattern which was there existing in ancient times. And that is how peace was achieved through this method. However, the indigenous method faded out, and now we have the modern system. Well, the reason for this growth we have all experienced, and we find from the various discourses that we have been listening, litigation's losses are high in terms of time, expense, and damage to relationships. Society has broken up, and today, as we all know, civil litigation is now transcending towards criminal litigation. A person does not file a suit for cancellation of a sale deed, and he straight away tries to exercise his right on the criminal side by lodging an FIR that the sale deed is forged, and then tries to negotiate things. Well, this is the reason why there is a need for alternative methods which are quicker, costless, yield practical and enforceable solutions while preserving relationships. I would put this in quotes. The maintenance and sustenance of society and its culture is one of those purposes for achieving peace through litigation. Well, with its focus on non-coercive and consensual processes, mediation is the fastest growing dispute resolution remedy worldwide. With the law being amended and the courts setting up in-house mediation centers, a wide ranging of cases, including civil, commercial, matrimonial, are being resolved by this process. And the results are astoundingly good, leading out of dispute and lifting out of dispute. We have seen Lok Adalats also, Well, mediation one way or the other adds to that. This supplement, of course, is now there to stay. In recent years, mediation has become the fastest growing ADR method. It has caught the attention of judges, lawyers, courts, policymakers, corporations, and other users. And it is largely free of the negative characteristics of adversarial litigation. After all, what is mediation? It is a process in which the mediator is an external person who is neutral to the dispute, works with the parties to find a solution which is acceptable to all of them. The crucial aspect is that the mediator cannot impose a result on the parties. The parties retain their power to make decisions. The mediator only controls the process. Mediation being voluntary, any party can terminate it at any stage. The process is confidential. Views expressed and proposals exchanged cannot be divulged in any legal proceedings. Such confidentiality, I believe, through various decisions, is mandated by law. Well, these aspects, autonomy of decision making, voluntariness, confidentiality, make this mediation process virtually a risk-free process. This gives greater confidence to the process, and as a matter of fact, it enables the participation of the disputants themselves in the conflict to resolve it themselves and by themselves. Well, the focus is on the future because, as I said earlier, relationships are restored, and relationships are restored for all times to come with these workable solutions which are brought forth in the mediation process. Well, much can be said about advocating this process of mediation, but when it comes to execution, we are slightly lagging back in trained mediators. The reason is lack of language. The reason is the lack of techniques. And the third is a little slow progress in the training of mediators. This training process, if speeded up, it can bring about very good results. I would say that when it comes to mediation, in the middle of everything, as Einstein said, every difficulty you will find an opportunity. But the situations which arise in mediation are something like when you are at the edge of a cliff. Progress is to step backwards. This is what mediation helps in. It allows you with greater flexibility to negotiate. And of course, it gives one of the most rational approaches of the parties themselves to understand what it is all about. Well, I would end by saying, rather quoting Abraham Lincoln, that discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. Thank you very much.
Honorable Lordship, thank you so much for your words of wisdom. By your words of wisdom, we understood that mediation is not an alternate, but it's an appropriate method of dispute resolution. Also, we understood that by way of mediation, we can create harmony and generate global peace by restoring relationship. Thank you, sir. By failing to prepare, you are preparing to fail. This quote is practically applied by our Lordship, President of today's function, Honorable Mr. Justice Deepak Mishra, former Chief Justice of India. Honorable Lordship, having remarkable work on universal concepts of individuality, liberty, and dignity of individual, right to privacy, equality of rights and freedom, Honorable Lordship emphasized on changes to be made in the legislative paradigm and legislative regime to incorporate mediation and related aspects and adopting policies which will propel mediation into action-oriented mechanism. Honorable Lordship also emphasized on pre-litigation mediation. So now, without taking much time, as we all are eager to listen to the commendable and glorifying words of Your Honor, I request Honorable Lordship to kindly address the august gathering. Over to you, Honorable Lordship.
Honorable Mr. Justice P.S. Narasimha, Judge, Supreme Court of India, Honorable Mr. Justice G.S. Sandhawalia, Judge, Punjab and Haryana High Court, Justice A.P. Sahi, Director, National Judicial Academy and former Chief Justice of Patna and Madras High Court, Professor Dr. Usha Tandon, Dean and Head Faculty of Law, University of Delhi, Professor Dr. Ashutosh Mishra, the Director of the Conference, Sonal Patil ji, ladies and gentlemen. Let me just pick up from Justice Sai's words that mediation is taken the course to because a cultured man or a thinking man or a concerned man with the collective amity desires peace. There cannot be a scintilla of doubt with regard to that proposition. But there is a snag over there. Philosophically and psychologically, the moment a man says, I want peace, that destroys peace. Because when you pronounce and give emphasis on I, it's a perpendicular I, a reflection of egotism. I want peace. No, man, don't say that. We want peace. The plaintiff and the defendant, the petitioner and the opposite party or parties, and all concerned. All of us want peace, right? And that is the element vital of the conception of mediation. Let's go back to the ancients. What have they said? There is a saying in Sanskrit, Santosham Paramang Sukham. When a man is content or a persons are content, or when you live in a contented society, that's almost like santosh. It's a delight in a different way. The nearest term that can come in English is ecstasy. Do not go by any other meaning of ecstasy, but the meaning I am suggesting today with regard to the purpose of mediation. I will not say mediation is one of the modes of alternative dispute resolution system. No, it is the most effective, the best, and presently the warranted form of additional dispute resolution system. It is a categorical imperative for today's society. I will give you two examples from my experience. I'll go to the doctrines. We are having a Lok Adalat at a particular place. And as told by my previous speaker, with regard to a compoundable offenses under Indian Penal Code, the accused was the cousin brother of the complainant. He had taken a challenge that he can slap the girl, and he did slap. That case was going on. I called them. It was a local dalat, but none of them were speaking. The mother was there with the girl was silent. Mother was speaking something, the boy was silent. I converted it to a mediation in a different way. I said, let everyone live. I will be alone with those three persons. Let's call it any step in mediation. The purpose is to achieve, not to theorize alone. I asked, what's the difficulty? Why are you fighting? Now, he did it to my child. Now, he's at fault. Then I knew one of the, the traditions of that area. I asked the boy to bow down to touch the feet of the lady, the maternal uncle's wife. The moment he tried to do that, don't do that. In our tradition, I am supposed to touch his feet. I said, then why touch his feet? Why don't you forgive? She smiled and she forgave, the daughter forgave, and a settlement was, a proceeding for compounding was recorded. I would like to call it a psychographic balance of mediation. I'll come to that slightly later on in a different way. A second case, I'm giving an example. A husband and wife had come. You see, it's a duty of the adjudicator, whichever strata he belongs to know whether there is a possibility of settlement. If there is no possibility, do not jump into fire. Do not get into that realm, because unnecessarily will lose trust and you will also waste time. I could know, I'm in the bench, it's a division bench. It was almost 20 years back, that it could be settled. Then I asked, what is the X? They are not qualified. You add 0. 0x, what's the value? The wife said, it's only X, left has no value. I said, all right, now X 0, 10, 1, 0, what's the value? Now it's 10. I said, no, ma'am. In a marital relationship, to sustain it, 0 has the same value on the left side as well as the same value on the right side. 10 on the left, 10 on the right. Believe me, ladies and gentlemen, they rolled into laughter and they told, we had not laughed since long. Now we'll go home. I said, may we kindly record this, that you have agreed to settle. It depends. This method may not absurd on every occasion, but this requires the psychological training, bent of mind, understanding the culture, the attitude, and getting into the innate psychological framework of the both parties who are contesting before you or appearing before you as a mediator. Unless you are aware of that, I have my doubts whether a settlement can be arrived at. Now, let me come to efficacy of mediation. Mediation offers efficiency and can enhance the quality of dispute resolution by permitting a wider array of outcomes and more client participation. Mediation process tries to resolve and check conflicts. This enables persons and groups to maintain a collaborative effect and they are to be given adequate opportunity to have their own say. You see, sometimes the mediator talks. They believe that the mediator is talking. So you must listen to them. What I would like to say, a mediator must have committed patience. He doesn't have to show erudition, though he has to be intellectually sound to deal with the conflict. Now, let me tell you two aspects. Mediation as a concept has to be understood as a legal science and artful craftsmanship. I would like to divide into the following spectrums on the first count. Why do I call it a legal science? First, there has to be diagnosis of the problem. Second, prognosis. I am using medical terms. Third, potentiality of contagiousness. When I am saying potentiality of contagiousness, a particular matter may be sent to mediation, but the mediator can settle 5 connected disputes pending in other courts. And that can be done taking recourse to mediation, but the parties settle. Last, the constitutional and symptomatic remedy. What Mr. Justice Sahi said, that there will be intergenerational amity or amiability forever, if I remember his phrase. I have like to put it as the constitutional and symptomatic remedy. When I am saying constitutional and symptomatic remedy, I borrow this phrase from homeopathy. There's a constitutional treatment as well as symptomatic treatment. The disease disappears. Okay. Now let's come to the craftsmanship. I've talked about the mediators, balance of mind, balance on psychology. One, psychological base. You see, whatever is applicable to Allahabad may not be applicable to Patna or may not be applicable to a tribal distant area in Madhya Pradesh. Why I am saying Patna? Because Justice Sahi was there and I was also there. And Madhya Pradesh, I was there for a long period. I've seen the atmosphere. Then psychopathology, psychographic balance, I've already given an example. Reduction of litigation pathology. You see, let us not say that people don't want to litigate. People want to litigate. It's better to welcome docket inclusion than to think of docket exclusion. But how do we normatively destroy or reduce this litigation pathology? And the last, with regard to the craft, a broader therapeutic counseling to break the positional stand. And that is what exactly required. As far as the modern day is concerned, and I could gather that there has been a lot of discussion with regard to the same, that there has to be a convinced idea with regard to dispute resolution by taking recourse to ODR method and all kinds of modern method. Distance should not be an impediment or barrier. I have few things to suggest. One, pre-litigation mediation in certain types of litigation has to be mandatory, and the provision has to be such that it has to reflect and can be interpreted as mandatory, having regard to the precedents of Supreme Court. I could see 2-3 high courts taking conflicting stands. That is up to the court. Second, there has to be spread of the idea of mediation amongst people of all classes. When I say all classes, I mean the heads of department of various companies, legal heads or their assistants, as well as ordinary people, all of us must trust the idea of mediation. Yes, our problem can be solved. The ultimate aim is the solution, and we have to enhance the culture of settlement. The next is the mindset of a person going for mediation has to change. Unless the mindset changes, he is embedded in his own ivory tower. He should imbibe the idea that taking steps for settlement is the strength of a cultured man and can never be regarded as a sign of weakness. You see, in Mahabharata, the settlement failed because of the obstinate attitude of Duryodhana and nothing else. Ati mane cha kaurava. That is what Chanakya says. That is why they lost. That is why there was a disaster and ultimate devastation. Having said that, I am reminded of a saying by Justice Warren Burger, former Chief Justice of American Supreme Court. What does he say about litigation that's applicable to mediation? I quote, people with legal problems, like people with pain, want relief, and they want it as quickly and as inexpensively as possible, unquote. The expediency and the cost effectiveness are both inherent in mediation. In conclusion, I would like to say, I'm extremely delighted that Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance in association with Mediation and Conciliation Project Committee, Supreme Court of India, have successfully organized this event. A great success, and each one of you is entitled to congratulate yourself. Thank you. Thank you very much for inviting me.
Thank you. Honorable Lordship, thank you so much for your deep insights into the subject. Your words are encouraging for reshaping the legal system towards the mediation being the future aspect. We understood that mediation is not only an alternative, but it's an additional and most warranted dispute resolution system, as well as when I turns into we, the illness will turns into wellness. Mediation is a legal science and constitutional and symptomatic treatment. So that's it. Now, I feel proud and honored to have our chief guest, Honorable Mr. Justice Narasimha, Judge, Supreme Court of India, as a chief guest. Honorable Lordship is a former member of Mediation and Conciliation Project Committee, Supreme Court of India, and having remarkable work in drafting mediation law, which includes online mediation and provide for enforcement of settlement agreements resulting through mediation, pre-litigation mediation, confidentiality, and other relevant points. Honorable Lordship having a proactive role in mediation activities as a member of MCPC, Supreme Court of India. Under the guidance of Honorable Lordship as a member of MCPC, we have conducted various trainings. Honorable Lordship is committed to facilitating and encouraging mediation and to make it success. It's my honor to request Honorable Lordship to kindly address the virtual gathering with his intellectual words. Honorable Lordship, the virtual floor is yours.
Thank you, Sonal Patil. Thank you very much. Honorable Justice Deepak Mishra, former Chief Justice of India, Justice Sandhawalia, Justice Sahi, Professor Usha Tandon, and Ashutosh Mishra. I must start with congratulating the Campus Law Center as well as the School of Public Policy and MCPC for organizing this. And I know a large number of persons who are integrally connected with mediation from the very beginning were involved in this. And the efforts made by them from the very beginning has now resulted in the probable bill which is going to be passed. There are three things which I just wanted to highlight. Firstly, it took about 75 years for us to realize, after having used the methodology of adversarial litigation, to now transit into the process of mediation. I am of the view that adversarial litigation has really not helped this country. But then it took time for the reason that we couldn't wriggle out of it. Anybody would realize that small issues like brothers seeking to partition their property are dragged into litigation for 30 years, 25 years. Simple issue relating to discomfort between a husband and a wife has led to so much of litigation. If you look back and see, is it really necessary that a system should operate in such an oppressive manner? It won't take much time for us to think that, to realize that this system of adversarial litigation did not really help us. But whatever it may be, it has taken that long time. And this thought led us to work towards it. And it looks as if it's now a reality to have an institutional mechanism where we will deal with these issues through mediation. And the problem doesn't stop here. We might have a legislation today, but then it will all depend upon how we are going to work this legislation. That's the biggest issue which will be there, which is going to confront us from now. And in that process, there are 3 or 4 things which I want to flag. First, I must actually congratulate Justice Deepak Mishra for giving a jurisprudential highlight to the issue, because what propelled and what propels litigation is the self-interest, the I, which is diametrically opposite to the methodology that mediation would adopt. Mediation says we. So we all need to be happy, and for that we need to resolve it in such a manner that we don't litigate any further. And this is also supported by the constitutional philosophy of fraternity. We have never adopted that. We need to work on it, and for that purpose, 2 things are very much necessary. First is that the necessary exposure for mediation for the judges. You know how it's going to resolve. It's not easy to wriggle out of the habit of deciding cases through the mechanism of petitions before the court. We have to get out of that mold, and it needs some kind of an exposure, some kind of seminars which need to be conducted. And equally important is to involve the lawyers in this. Unless that happens, the legislation will only be on the paper. Many lawyers don't have a very clear understanding of what this mediation is going to lead to. There is an apprehension that there is no what's called a revenue model in the mechanism of mediation. Where does it lead them to? So one has to take them into confidence. And the other day I had a discussion with the Bar Council members who were to make a presentation before the subcommittee. These were the issues which we were discussing. And that mechanism, that involvement of lawyers would be beneficial to them is also an important aspect which needs to be told. And the number of pendencies that are there in the courts, unless we adopt the mediation, unless we enroll more number of lawyers towards that purposes and resolve it independently and simultaneously with the adversarial litigation, our problems will not be solved. Institutionalization, the third part, I just will conclude with this. once the act comes into force, various aspects have been gone into, you have discussed at length. I should actually congratulate you. The kind of sessions that you had on the various topics that were taken are really very good, because substantially resolves many problems that were there in the minds of those who were involved in the drafting of the bill. Much would depend upon what kind of leadership one would offer once the act comes into force. Who is going to take over the council chairman? How he is going to implement the various issues? The mediation service providers, how are they to come in which manner they will be recognized? Would every lawyer double up as a mediator? Issues like accreditation. These are all aspects which will depend upon, the flourish would depend upon the leadership that we're going to offer under the act. It needs to be worked on. That is where the government role becomes very, very important in identifying and appointing a very important, very able and an eminent person to head and run the institution of mediation. I think with this, we are now into a very different segment in our constitutional process of access to justice. And I am very positive about it. And I think things are going to change drastically if we work in a positive way and involve not only those who have specialized as mediators. One aspect of it which needs to be remembered, and one should be cautious about it. We should prevent this mediation to again become some kind of an elitistic methodology of resolution of disputes. Some amount of idea is there in the members of civil courts as regards arbitration, thinking that it is intended only for the purpose of, the big and the wealthy, or for the commercial litigants, and it is not useful for the ordinary litigation. That impression must go. And it's very important to make mediation work across the board and also to resolve simple issues such as partition, as matrimonial issues, and so on. So with these thoughts that I have in my mind, I'll conclude by again congratulating one and all. And thank you again for giving me this opportunity. Thank you very much.
Thank you so much, Honorable Lordship. Thank you so much, Honorable Sir, for your expansive vision on mediation at any stage of litigation, duly to be noted. And also, the message is that let us mitigate than litigate. Thank you. I would like to request respected Dr. Ashutosh Mishra, Assistant Professor, Faculty of Law, University of Delhi, to express gratitude. Over to you, sir.
Good evening to one and all. It gives me an immense pleasure and honor to deliver a vote of thanks on behalf of Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, and Mediation and Conciliation Project Committee, Supreme Court of India, in this virtual gathering of Third International Conference on Mediation. I am extremely honored, privileged, and grateful to Honorable Mr. Justice P.S. Narasimhan Sir, Judge, Supreme Court of India, and Chief Guest of the Valedictory Session for taking out time from his busy schedule and accepting our invitation. Sir has played an instrumental role in Mediation Bill, and Honorable Sir have enlightened us on relevance of mediation and relevance of mediation in future perspective as well. I would like to extend my sincere gratitude to former Chief Justice of India and Chairman, Governing Body of Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, Honorable Mr. Justice Deepak Mishra, for giving presidential address. Sir is a great jurist. His word of wisdom and gracing the occasion with his presence today and sharing his insights on mediation is a great motivation for all of us. I express my sincere gratitude to Honorable Mr. Justice Amreshwar Pratap Sahi sir, Director, National Judicial Academy, India, for accepting our invitation as guest of honor and enlighten us on various significant perspectives of mediation. He explained how mediation is a pacific settlement of dispute, and he had discussed the enforceability aspects of mediation as well. I would like to thank our special guest, Honorable Mr. Justice P.S. Sandhawalia, sir, Judge Punjab and Haryana High Court, for providing such a crisp summary of the conference and sharing his valuable experience. It is coincidence that sir has been our guest in all the 3 international conferences on mediation till now. It reflects sir affection and commitment toward mediation. Thank you very much, sir. I am sincerely obliged to Honorable Vice Chancellor, sir, Professor Yogesh Singh, sir, for giving us precious time and all support. I am thankful to Professor Usha Tandon ma'am for constant support, ideas, and appreciation throughout the process of this conference. We are honored to have you as our Dean and Head of the Faculty of Law, University of Delhi. My sincere gratitude to MCPC for their association with us as our knowledge partner. I am highly thankful to Honorable Chairman MCPC, sir, Honorable Mr. Justice Amreshwar Rao, and Member MCPC, Honorable Mr. Justice Sanjay Kishan Paul, and Honorable Mr. Justice Kumar Shah for their assistance. I also extend my thanks to the Chief Justice of different High Court and judges of various High Courts for accepting our request as a speaker. I am thankful to Mr. Yajwinder Singh, Member Secretary MCPC, and Sonal Patil.
It appears there is some connectivity issue, Dr. Ashutosh. At least with me, I'm not able to.
Yes, we also can't hear.
I'm not able to listen.
I think you can conclude with from the
Yes, sir.
point
Yes, sir.
where he has stopped.
Yes, sir. Absolutely. Thank you so much, Ashutosh, sir. I must also thank the very distinguished speakers who joined the conference, who have given us many fruitful thoughts and insights regarding the future development of mediation in the whole world. Therefore, let me wish all of us a lot of energy, enthusiasm, shared trust, and resolve on our way towards achieving a better future for all. I wish to conclude with one quote of Bhagavad Gita: सर्वभूतेषु यनेकं भाव्यं यक्षमिच्छति अविभक्तं विभक्तेषु तत्त्वज्ञानं विद्धि सात्विकम्. It means the knowledge by which one undivided spiritual nature is seen in all living entities, though they are divided into innumerable forms. You should understand to be in the mode of goodness. Thank you. With kind permission of honorable dignitaries, I declare the valedictory session is over. Thank you.
Thank you, sir. Thank you so much, sir.
Welcome.
Thank you, Lordships. It's always a pleasure to listen to you, sir. I mean, the way you have put the things together, bringing the other disciplines also in this, it's really, really wonderful.
Can I only say thank you? Okay.
And Sir Narasimha, also very natural and that way that you have explained the things, all of you. We are really honored to have you, sir. Thank you so much. Thank you.
Welcome.